Good afternoon. Are you still in the Keys?
Yes, sir, I am.
No, good for you.
I know, it's nice down here.
It's not that great here. We had one good day this week.
Oh, dear.
It's okay. It's in the 50s.
That's not that bad. It's in the 80s here. It's quite warm. So you've been busy?
Well, I was on vacation. I've been very busy this week. Judge Pattison was gone. We've had a full day today.
Mine shouldn't be bad.
We're on the home stretch here.
So where'd you go on vacation this year?
I went to a secret location.
I don't blame you. Got to get away from it.
Where it was warm.
Larry's up there now. They're trying to sell his parents' house.
Oh yeah, I saw that his dad had passed.
Yeah.
We discussed that. He was a contemporary of my father-in-law.
Right. And we got his mom back to Michigan. She didn't, because she had nobody in Florida. So we brought her back. We got her in Bowman Place.
Oh, I think that's a good spot.
It is, and she's been so busy, and she couldn't leave her room at the nursing home in Florida. So they got her. We got her into Bowman Place, and she can't even talk on the phone. She's so busy.
Yeah. Oh, good. All right. We had a very busy morning. We're ready to start our afternoon. The first matter is Terry and Larry Richmond versus Tyrese Howell and Emmanuel Cutledge and any others. This is for a property at 809 5th Street.
Correct.
Said as a non-payment of rent case, the arrearage is alleged to be 11742 plus I think some more. Bettina Emery is here from Keystone, our housing advocate. She was with us this morning, and Mr. Howell or Miss Cotledge are not here. What do you know about this, Ms. Richmond?
Okay, through April, they owe me $542.42 plus $145 in court costs, and then tomorrow another month is due.
All right, and it's $740 per month for
That's
May.
correct.
All right, $540 plus $740.
Yeah, I think it's $1282.42.
They owe $542.42 or $540.42?
$542.42.
Oh, without the two. $1282.42.
Right, that's what I have, plus $145 in court costs.
Well, this is our first hearing. They were personally served. Let's see if they were both personally served.
I believe so.
Yeah, they were.
Yeah.
Here's Kylie. Let's see who this is. Maybe it's Kylie Minogue calling in from Australia.
Really?
No. I think she might be here on Shelton. Are these parties still in the premises?
Yes, they are. And we sent notes out when we sent our evictions out to contact Keystone. And I only know of a few that have contacted them, and most of those are old. I'm still waiting for payments from Keystone from December, January, February.
Well, the money got replenished and Bettina got here And they've got an online application process.
Right. Lydia's been helping them because most of my tenants can't get online. They don't know how to do it. They don't have computers.
Well, I
So,
committed for that.
so Lydia's been helping them. They've come into the
Let's
office.
see who this is. We have a phone number. I lost whoever that was. Good afternoon. Who am I speaking with?
This is Betty Callahan, property manager at River Trail Apartments.
All right, Ms. Callahan will be with you shortly.
Thank you.
Let me get a name. Ms. Shelton is here in the next case. Anyway, have you had any contact from these parties, Bettina?
From the Howl party? No,
Yeah.
I have not.
They were there in December and Keystone paid them up then. And then I forgave some. That was the program in December. So we told them they could go back, but I haven't heard anything.
The previous program, I don't have any affiliation with that program, so I
Right.
can't vouch on behalf of what happened in December. But as far as the Sarah program, I have not heard from them.
Well, Terry, here's our situation. People tend not to show up on time. We try to start right on the tick because we have a lot to do. They are subject to default. I could enter a default judgment in that amount with a writ date for 7 days. If they appear, they're entitled to have a second hearing 30 days out. So, and they have not applied for a COVID stay. So if you ask for a default, I'll do the writ with
All
a
right,
writ date.
I think they normally pay up. So I think I'll ask for the writ, if I can get a default judgment, and then I can work with them. It's easier to do it. And then if the problem is when they owe you money, they're afraid to contact you.
Yes.
And so we started writing letters and told them if they contacted Keystone to please let us know so we know to work with Keystone and what their intention.
Well, we got a filing fee of $110 and
a service fee of
$35.
Correct.
$145 plus default $1,282.42.
Yep. $1,426.42. Date for the writ is 10 days from today, which is a Sunday, so we're going to go with May 11. Okay.
By default, I'm going to ask you to stick around for just a minute to make sure they don't log in late.
That's fine. I think some of these people that have applied at Keystone before think they can't get help again. I think he works in a restaurant. I think he works at that went out on 131.
Oasis.
Right.
Well, we'll see. We've got a new funding source, a new program, a new way to apply, a new person doing it. As you know, we ran out of money. We had more demand than we had supply. And we got through January by hook or by crook. And then we were kind of in limbo for a while until the new money kicked in March. But it doesn't hurt to ask.
Oh, I know.
And, at this point, they're not terribly behind. They have paid some. So
Right.
do that and just stick around for a minute, and we'll do our next case, and if they don't show up by the end of that, I'll let you go.
All right, not a problem.
All right, here are our next two participants. Good afternoon, Ms. Shelton. Can you hear me?
Yes, I can.
Good afternoon. This is Judge Middleton. The attorney for River Trail is logging in, and the manager is here. Tina is also here from Keystone. Can you turn your camera on? Thank you. Hello. This is file 21510. It's entitled River Trail Apartments versus LaShonda Shelton. Mr. Robert Soltis is connecting on behalf of the apartment complex. Ms. Shelton, you've been here a couple of times recently. File 192760, 20463, 201671. So this is the fourth action they've had in a little more than a year. This one's a little different. The others were all filed as a non-payment of rent. This is filed as a termination of tenancy. They want you to move. I've read these to you before, but I want to remind you of them. I'm required to tell you what your rights are in a landlord-tenant proceeding. As a defendant in a landlord-tenant proceeding, including termination of tenancy, which is what this is, you have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. You have the right to a trial by a jury or by the court. If the action is for non-payment of rent, which this isn't, Keystone could be available to help. If the plaintiff is agreeable, a citizens mediation service could be available as a possible source of mediation. If the parties are interested, the court can help set that up. If you do reach an agreement with the plaintiff and a consent judgment is entered by the court, you will waive the rights listed above but have the following additional rights. The judgment may not be enforced until 3 business days have passed. You may move to set aside this judgment within those 3 days if you misunderstood what you consented to or what you were waiving. Your motion to set aside the judgment will be set for a hearing. However, if the judge does not find in your favor, the original judgment would stand. So, Mr. Soltis, the way I'm reading this, I mentioned the 3 previous dates. I think she got some assistance in some previous occasions, but the lease expired in February, and at this point, the complex is simply asking to terminate the tenancy. Is that correct? Ms. Shelton, what's your position?
Well, I tried to get it. Well, I was in contact with Betty about renewing or not renewing my lease. I didn't want to do another lease. I wanted to stay here for at least like 4 more months to give me time to find a place in Texas because that's where I'm moving to. And then Betty then informed me that there was nothing that they could do. They just wanted me out of the apartment. So I was asking her, why is that? And she told me that I needed to speak with corporate. So she then informed me that she had to give my personal number to corporate, which is fine. I waited for corporate to call me. I never received a phone call from corporate or anything. So I contacted Betty back, and she just said that, she passed my number along to corporate and there was nothing that she could do as far as corporate reaching out to me to figure out like why I couldn't do like
Ms. Shelton, just to let you know, you're on camera.
Yeah, I'm aware. I have things that I need to do as well.
Okay, well, all right. If we were in a courtroom, you wouldn't be doing your hair like that. You're at home.
Well,
this is a court
proceeding. Turn the video off?
Yeah, that's probably fine. Okay. All right, so I have to set this for a second hearing. They want you to move. And I guess your answer from corporate was they filed this action. I have to set another hearing at least 7 days away. When were you planning to move to Texas?
Well, I needed time to find a place in Texas. I figured out at the beginning of the year that that's where I was just going to move me and my son to. And with not having any information from River Trail or corporate contacting me to figure out why they didn't want to do a month-to-month lease or whatever that situation was, I just never heard back from anyone. So now I don't know when I can move to Texas because I've been dealing with this. I haven't been able to go out of state and actually look for a place.
Okay, well, all right. What part of Texas? Do you have a selection or just Texas in general?
It's in the Dallas area, like the Arlington, Grand Prairie area.
Well, one of the problems, Texas is a mass exodus from California. There's a Chris Ray song called I'm Going to Texas. Texas. People are moving there like crazy right now.
Taxes are.
And you don't sound like you have much of a plan, but the problem is they're not going to wait around for you to execute your plan.
Well,
I'm going to set this for a second hearing for, let's look at the 10th. Mr. Soltis, are you available? Well, the 10th is packed.
Depends on what time, Your Honor.
2:45?
That would be fine.
That'll go to May 10th at 2:45. Now, you have an opportunity to try to get counsel to help you, but at this point, your lease is up. You don't want to sign a new lease. They don't want to do a month-to-month, and they're asking for the property back. So if they get what they asked for, you would have 10 days from May 10th to move. That's not a lot of time. So there's no allegation that the rent is in arrears or anything at this point. They simply want the property back. So we're going to send you a new notice. It will be by Zoom like this once again for May 10th at 2:45. Is that acceptable for you?
okay.
Ms. Shelton, does that date work for you?
Sure.
All right, we'll try this again for a second hearing, May 10th at 2:45. All right, do you have any questions?
Nope.
All right, Mr. Soltis, anything further?
Nothing further, Your Honor. Thank you.
All right, I'll see you both on May 10th. Thank you.
Thank you.
Ms. Richmond, your people haven't shown up, so I'm going to go ahead and release you also.
All right, well, you have a great day.
All right.
I'll probably be home in a couple weeks.
Well, it ought to be warm before then, so I think it's probably safe about next week.
Yeah, Larry's
All
doing
right.
an estate sale at his parents' house today and yesterday and today, and it's just cold and rainy.
Yeah. All right, good luck.
Hey, thanks.
Bettina, I think that's all I got for you. The next one is a health hazard, and then it's a termination of tenancy, and then another guy, although I might need some help on the last one, 150. The
150.
guy is homeless, or about to be homeless,
Okay.
and he doesn't want to move. But anyway, these next two I don't think are in your wheelhouse.
Alrighty. I'll be back at 150.
All right, thank you.
Thank you.
Mr. Barnell, can you hear me?
I can, sir. How are you?
All right. I'm fine, thank you. Let's wait a little bit for the clock to tick. This is set for 120.
All right.
Mr. Barnell, can you turn your video on?
Oh, let's see. How do we do that?
Right now, you're just a crimson screen.
Let's see. How am I supposed to do that?
Is there a little camera icon down in the corner? I'm not sure what kind of a device
Oh.
you're on.
It says stop the video.
Yeah, hit that.
Okay.
Should start video, but I've got as I said, just a crimson screen.
Yeah.
All right, I guess we'll have to just make do with that. This is file 21500LT. It's entitled Bradley Barnell versus Damian, you say it Grace?
Grace, yes.
This is for a property out on Sherman Mill Road. It's pretty out there, but it's a real good place to hit a deer.
It is.
And this defendant, his parents must have been rockers. His middle name is Aerosmith. Damian
Yes.
Aerosmith Grace is in your property. There is no lease. You indicate that he is damaging the property, causing extensive damage to the walls and windows. And what's going on here?
I had initially rented it or was selling it to a young lady who I had employed and had then gotten close to because I followed her through her prison time and rehab and stuff, and she's making good progress.
Well, who is that person?
That is Lacey Grice.
Okay.
Used to be Lacey.
Was there a land contract? Was there a land contract?
It was more of a gentleman's contract, gentleman's agreement.
And then he moved in and she moved out?
Well, they married, and around Christmas time, he allegedly knocked her out, and she moved to her mom's and hasn't been home since. I confronted him over it. He said, "I'm sorry, Dad, I messed up." He didn't come right out and admit it, but
So are you related to this guy?
No.
Well, he's there, he doesn't have a
He's there.
lease, he's damaging the property, he was
Right.
personally served, and he's not here.
Correct.
So he's subject to default. I don't have a judgment, but I'll have the clerk prepare one.
I've seen the front screen door is broken, the handle.
Why is he tearing it all up?
I'm not sure. I really don't know. She had said something about him standing by the front window with baby in hand and banging on the window.
Is there
But
a
I didn't see
child
any
there?
Yeah, less than a
He's
year
there-
old.
He's there with a child?
No, I think she took the baby and the other daughter with her to her mom's. But
All right,
when,
well, that sounds like a mess. Now, it's a mess several ways. You don't have a lease. If you
right,
put somebody else in there, get a lease for your
I'm
safety.
selling it.
And secondly,
Yes,
he's not here, he was personally served, and he's subject to default. So I'm gonna do a judgment of possession with a date for the writ of May 11th.
okay,
Does not move out by May 11th, you bring $15 to the courthouse and you get a writ of eviction, and the sheriff will come throw them out.
okay,
But in the meantime, your property is continuing to be damaged. I'm not gonna do an immediate writ, but I'm doing the 10-day writ. So,
Okay.
he has till May 11th to move, or he's subject to being evicted.
all righty. Then that's-
You didn't do a judgment, but I'll have the clerk do one.
On the eviction, then he's given what, like a time period to get out, like half an
10
hour
days.
to an hour? Or
No,
what
if he's,
beside that? If he's
no, they'll
served,
come, he's served now, the sheriff will show up, crew to throw him out.
okay,
Actually, Sergeant Morse goes and meet with him first, but,
sure.
but yeah. All right, now you're in Indiana, or?
Yes.
So, the 10th day is May 10th. That's a Sunday, so I put May 11th. So if you didn't submit a judgment, but I'll have one prepared. All right,
Okay.
you're free to go. Thank you.
All right, thank you, sir. Have a good weekend.
Thank you.
Without having to have a hearing. And another 56 days. A total of 100. Possible. What's that? Possible is less. I mean, those are the possible days that they can. Sure, you can't do it before 10. You've got up to 56 without a hearing. And then you've got 56 more days after that, but you gotta have a hearing for that. So, this next order for 10 days. You can't kick them out for at least 10 days. Okay. But you've got up to 56 days to get the writ of eviction without having to go back to court and have another hearing. Oh, you mean if we decide to make? If you decide to let them stay beyond the 10 days. Uh-huh. Okay, so what's happened, now this here's for the 10 days to get out? Okay, what happens after the 10 days? If you want them out, let me know, and I gotta get a writ of eviction filed with the court. You wanna let them stay a little bit longer than the 10 days, then you gotta let me know when that is, but it's gotta be before 56 days. Yeah, but I ain't getting any income coming in right now, so the sooner I can get them out of there. Yep, understand. Got people lined up and they ain't no good with. So I don't know why we got zoomed in. There's nobody there. And then you see the judge get up and leave? No, yeah, he was there. Oh, okay. He might have 130s first, if he does, because they set these every 10 minutes. So if he does, he'll take those first. Well, he'll explain it to them also, that you can't get the writ before 10 days. You don't have to get it on the 11th day. You can wait up to 56 days. But again, like I say, if they're not holding it, I gave you an intake form, so they have to fill out an application with all kinds of info.
Andy, I left a record running. I apologize. I had to go get a cough drop.
No, COVID.
It's not COVID. Well, I don't think it is. Just did my last
That's
case.
a 140.
Now we've got some dead air here.
Yeah, I was just explaining, Mr. Foreman, he can't get the writ for 10 days, but he's got up to 56 days to get it without a hearing.
Well, this was a termination of tenancy. They did say they called legal aid. I haven't heard anything from legal aid. Have you heard anything from them?
Not a word.
Had a couple of no-shows with one girl who this was an inconvenience for her. Yes?
We've noticed that you've been saying that the 9th is, or the 10th is on Sunday, it's extra Sunday,
May 10th?
May 10th.
I'm looking at the wrong year. Duh. Well, they get an extra day, so thank you. I'll go back to the 10th. Yeah, I'm looking at it right in front of me, but it's 2020. Thank you for straightening me out. Are the parties still there?
As far as I know, are they still there, Dennis? Yeah.
Okay.
And you got my proposed order for Monday too, didn't you?
I haven't looked at Monday yet. I was going to do that when I
Michelle
finished here.
called me and I emailed it to her probably Wednesday.
All right, I'll put you in the waiting room so you can be more comfortable. I'll bring you back in a minute. I'll just sit here and dissolve my cough drop. We'll wait for 9 minutes. All right, I think she's here. We can start.
Piece of cake.
She's logging in, hopefully.
So Monday at 9 o'clock, you're Zooming law day?
Yes, I have a couple of pre-trials that I'm gonna have to just wait. But I've got all the notices out. I did the press release.
Zoom into your courtroom?
Yeah, I sent you an invite, I think.
Yeah, but it was real hard to read. It wasn't a standard notice.
Well, then I think but yeah, just log into my court. That's a good candidate. She deserves to win it. Ms. Wiedemann, can you hear me?
You guys,
I've been
I can
chairman.
hear you.
All right, can you turn your camera on?
I'm trying. I'm hitting what
Okay.
it's telling me to, and I can't. For
It
some
shows
reason.
your name. I think we're getting close.
My light's on my laptop. I don't know what.
Is there a little icon down in the corner that shows a video camera?
Yep, and I keep clicking on that, and it won't open it up. It says start video, and I'm hitting it.
All right, well, do you have a hammer?
Yes, I do.
I have one too. I'm tempted to use it sometimes on my equipment, but I've been so far restrained. All right, we'll just go with what we got here.
Okay.
This is entitled Dennis Foreman versus Billy Joe Wiedemann and others, Corey Wiedemann.
He is here today, but he had to go get tested this morning for COVID, so he's locked in our bedroom.
Okay. Well, this is a termination of tenancy action. There's a week-to-week tenancy. We were here previously on an earlier date, April 9th. We adjourned it for 3 weeks to today. Mr. Rognus, does your client still want the premises back?
yes, sir, Your Honor. I did explain to him that he couldn't get the writ for at least 10 days, but the fact that he did have up to 56 days after that to get the writ without a hearing, and then an additional 56 after that with a hearing. So we're prepared to move forward, have the judgment at least enter at this point in time.
Ms. Wiedemann, what's your position?
Still the same. We can't find anywhere.
Well, that's a common phenomenon. The plaintiff is entitled to the relief they're asking for. I'm going to grant the judgment, and I'll explain a little further. Mr. Rognus touched on some of this. You have until May 10th to move.
That is the day, the day my mom passed.
I'm sorry. Now, let me explain. Mr. Rognus indicated, and I'm going to repeat it, they don't have to get the writ of eviction on May 10th. They have 56 days from today to ask for the writ. So if you're in the cusp of finding another place to go, they can wait. But the purpose of these hearings is ultimately to force people out that don't want to move. is what it boils down to. When the landlord wants the property back, the tenant doesn't want to move, the landlord has certain steps they have to follow. And they started this process some months ago. I don't remember when the first notice to quit was served. And then they inserted an additional step where I had to adjourn it at least 7 days. I adjourned it 21 days, and now I've done the writ for 10 days. And at its worst, the sheriff comes and puts your stuff out on the street. Mr. Foreman does not have to evict you on May the 10th, but he has a right to do so. He can work with you for up to 56 days from today. You do also have 10 days to appeal this, which is to May 10th. So I suggest you stay in contact with Mr. Foreman. This is a difficult time to find housing, but he's entitled to the relief he wants, ultimately, if he follows all the steps, which he has done. So the date of the writ is 10 days from today, which is May the 10th. He doesn't have to serve it on May the 10th. He's got 46 additional days of discretion. And my suggestion is you stay in contact with him or go through his attorney. Do you have any questions?
Yeah, I might want to give him the notices about the written forwarding address and the keys, etc.
Oh, yes. When you do move, if you do move, you need to turn
Where to go?
All right. Well, I'm just telling you what the rules are. It happens a lot, and they don't have to just provide you a place to live. And so I get push comes to shove, they ask for their premises back. And as I said, if they follow the steps, I would also suggest perhaps that you contact Keystone Place. They may have some housing placement options available. Do you have applications out?
So yeah, there's nowhere that's taken them.
Well, that's not exactly true, but you also, where do you want to live?
In this area, my husband works in Shipshewana.
Okay, I'm not sure what the situation is over the border in Indiana, but here in my county, I've got a handle on it. I wish I had a better answer, but I don't.
Well, my friend told me that this happened to them, and they paid for a jury trial.
Well, you didn't ask for a jury trial or pay the fee. You do have 10 days to appeal this. You indicated you were going to call legal aid. Did you ever talk to them?
Yeah, they make too much money.
All right. Well, I'm sorry. I don't have a good answer, but ultimately it's the landlord's property, and if they want it back, what would happen is no one would ever move. They would say, well, truthfully, I can't find a place to go. I've had people be there I got one guy, he's been there for 13 months. He still won't move, but his is a different kind of case.
Your Honor, I would indicate my client says that originally they were in the Tower Motel on 31. They moved into his place because it was cheaper, but I think Tower Motel still has spaces available.
I don't want to move it in a place that's got bed bugs either.
Well, I don't blame you there. All right, I'll send you a copy of this order.
Okay, thank you, Your Honor.
All right. It's a tough time for people. And when the rock and the hard place meet, you follow the law, and the law says you follow these steps, you get your property back. There's nothing that requires you to provide housing to someone other than the conditions of a lease. Bettina, we just had another tough one where the landlord wants the premises back and the tenant didn't want to move and hasn't got anywhere to go. Miss Wiederman, did you come back on? There you go. Can you hear me? Before I could hear her but not see her. Now I can see her but not hear her. And her picture's frozen.
If you could send me her contact information, I can reach out to her.
I don't think I have a phone number. Her name is Billy Joe Wiederman, but I don't have a phone number. I don't think. Let me look.
I can go on the previous dockets that I have to look up her information possibly. I think I have it right here.
Well, she could use some help.
Okay.
It'd be nice if we had a limitless supply of affordable housing to refer people to.
Yes.
But we don't have a limited supply, and some people affordable housing is zero.
Mm-hmm.
All right, now our next matter is set for 150, and it is 150. Mr. Hughes isn't here yet. We've had a lot of those cases today. Termination of tenancies for one reason. Well, one we did, the guy was tearing the house up. And he didn't show up. He got defaulted, but
That's unfortunate.
Miss Pennington, was Miss Hall gonna appear?
To the best of my knowledge, yes. I have just sent her a reminder.
Okay. Mr. McDonald, can you hear me?
Yeah.
All right. We're waiting for the attorney to log in. I'll send her an invitation.
Your Honor, I'm not getting a response at this time, so
I'm sending her an email. See if it got noticed. Well, you got noticed, so it must be. That's to Stephen K. Gann. Well, this is frustrating. Let me try to call him. Did you have any success calling that number?
I did not.
Just no answer?
I'm getting a voicemail, but it's not actually Dana's.
Well, let's see what I got.
Again, I'm going to take a collect moment, but please leave a message, including your name and telephone number. I'll call you back as soon as possible. Thank you. Please leave your message after the tone. When done, hang up or press the pound key.
Mr. Gann, this is Judge Middleton. I'm calling from the bench in the court in Centerville. We started a hearing on Gateway Village Sturgis Housing versus Robert McDonald. The attorney had been appearing was Dana Hull. It was set for an emergency hearing some time ago for today, and no one has appeared. Your manager is here, Cindy Pennington. The tenant is here, and I sent an email to Ms. Hull, and no one's here. So we're gonna try to figure out how to proceed, but we aren't doing very well without counsel for the corporate plaintiff. Thank you. Well, maybe they took Friday afternoon off. Mr. McDonald, can you hear me?
Yeah.
This is file 21235LT. It's entitled Sturgis Housing Commission as limited partnership with Gateway Village in Sturgis versus Robert McDonald. We had a hearing, several, and the most recent hearing was in late March. And I ordered that you be moved by April 3rd or you'll be subject to being evicted. You didn't want to move then, you don't want to move now. They want you to move. We had a hearing. They alleged you were habitually late with your rent, that you had people in there that weren't supposed to be in there, like Nicole Samuels and Cody Brownridge. And I moved that they had found material non-compliance with the lease and that you had to move. You had written me a previous letter saying, well, I'm going to be homeless and my kids are going to be homeless and I don't want to go. Well, this isn't my idea. It's your landlord that wants you to move. And I ordered that you do move, and I ordered you move by April 3rd. Well, you didn't move. They did request the writ of eviction. I'm not sure what day it came in, but I think you, I don't know if you called or what you did, filed something to trigger this emergency hearing. what's your position here?
Well, I mean, I guess for one thing, I was never given a notice to quit for the unauthorized tenants.
That ship has sailed. We had a hearing, and I've made a finding that there was a material noncompliance with the lease. We heard all that stuff. Have you made any effort to find a place to go?
Yeah, I've been trying. I got some stuff from Keystone for hotel vouchers.
Well, I've got Keystone here with me. I asked Bettina, our housing advocate, to click in for this hearing. I really isn't my desire to make you live out on the street. I've had a lot of very difficult cases today, Mr. McDonald, where the landlord wants the people out. The people don't want to move. I left the last lady in tears. They haven't got anywhere to go. But I don't have the right to say, well, I'm going to ignore the law. You can just stay there. That's what the purpose of these hearings is for the landlord to be able to get the property back. I found a material violation of your lease, and in addition, they gave you a whole other, they were eligible for the writ of eviction on April 3rd, and here we are on April 30th, and we still haven't served it. So if we waited for people to move, they never would move. So you have contacted Keystone?
Yeah, I've tried to, yeah.
When?
Last week.
Bettina, you have any record of that? All right, here's...
I believe we're still waiting on further documentation for his file. I will have to contact the St. Joe case manager to find out exactly where he's at in his file.
All right, so have you, I had a lengthy hearing. We had two or more. We were here on March 8th. We were here on March 22nd. We had testimony and lengthy findings, and I found a material noncompliance of the lease. I can't just indefinitely let you stay there because you don't want to move.
Right.
Counsel has now joined us. She was here at both of those earlier proceedings. Ms. Hull, we started because we didn't know when anyone was going to come.
Yeah, I apologize for that. I don't know how it didn't get on the calendar when I'm the one that reminded everybody to be here.
Okay, well, all right. Mr. McDonald has not vacated. Keystone Place is here. They can't pay his rent. They simply want him to move. To your credit, you waited a while before you asked for the writ. He was eligible for the writ as of April 1st. It's now April 30th. Are you willing to give him some additional time before I execute the writ?
No, not at this time, Your Honor, just because he has already had an extra month. I think their manager's concern is that he just won't vacate if we continue to give more time.
I do have a question.
Yes.
Is this apartment complex backed by Fannie Mae?
I don't know the answer to that. It's a federally subsidized place. Your time for appeal has passed. I don't know the answer to that. I recommended at some point that you contact legal aid. They have zero grace. They want you to move right now. They want me to have the sheriff come put your stuff out on the street by 5 o'clock today. And I'm not willing to do that. I'm going to hold for the execution of the writ till next Wednesday.
Thank you. That's what I was going to ask for.
To May 3rd.
But, I'm sorry.
Mr. McDonald, I know you don't want to move, and none of this was my idea, but your landlord wants you to move. And some of this is your own damn fault. In fact, much of it is. And they want you to go. And I wish it weren't so, and I wish there were some place for you to go to. It makes it very difficult for you to get into other subsidized housing when you get evicted from the last one. This is further.
I'm not subsidized right now.
Okay, well, good. Anyway, you got till next Wednesday at noon to move, or I'll sign the writ of eviction.
Okay. To go off of what I was asking before was that Fannie Mae has their own moratorium in place, saying that anybody that's backed by Fannie Mae cannot evict anybody under any circumstances until the end of June.
Well, that may be for non-payment of rent. This is different. This is for material non-compliance of the lease.
It's for possession of property.
So somebody can tear up the apartment and set it on fire and cook meth in it, and they won't evict anybody till the end of June? I don't think so.
Well,
and I'm not saying that you did those things, but I'm saying that if someone did, under that theory, they wouldn't be able to do it. I don't know the answer to that, but we're all stuck with this. So the best I got is you got till next Wednesday at noon, or I will execute the writ. All right. Good luck, sir. All right, I've got the writ here in this hall, and I'll hold it till Wednesday at noon.
Okay, thank you. Thank you for letting me know about the hearing again.
Well, I'm not exactly even sure what triggered this. He had sent all that other stuff back in March, and you were there when we had the hearing. And this is about the fourth unpleasant termination case I've had so far today.
I think he was calling the court a lot.
He was.
The hearing.
He was calling about 3 times a day, and so I just said set it, and I may have alluded that I might set an emergency hearing. Anyway, he's got till next Wednesday at noon. All right, thank you.
Thank you.
All right, Tina, maybe they can find something to help him, but all right. All right, I got one more thing. Hello, Deputy Metz. Judge Middleton calling.
Hello, sir.
Could I see Lonnie D. Williams III
You may.
at Polycom room?
Yep.
All right, thanks.
Yep. Bye.
Well, I think I'll